Picture this. A bloody glove that won't fit, a missing child with no cause of death, a teenager shot dead, and the shooter walks free. A global superstar accused of the worst imaginable crimes. 4 cases that had America convinced the defendants were guilty. 4 trials where the evidence seemed overwhelming. The public had already reached their verdict, and conviction felt inevitable. But then, something happened that shocked the world. O.J. Simpson, Casey Anthony, George Zimmerman, Michael Jackson, names that still divide dinner tables and internet comment sections years later. Not because of what they were accused of, but because of how they beat the charges. These weren't lucky breaks or technicalities. These were masterclass defense strategies that turned certain defeat into stunning victory. Today, we're looking at the courtroom tactics that prove sometimes the best defense isn't proving your client's innocence. It's making the jury question everything the prosecution thinks they know. O.J. Simpson. Back in 1995, the O.J. Simpson trial wasn't just a case. It was a cultural earthquake. Every TV station, every newspaper, every conversation seemed to revolve around one question. Did the football legend murder his ex-wife, Nicole Brown Simpson, and her friend Ron Goldman? On paper, the prosecution looked unbeatable. They had DNA evidence linking O.J. to the crime scene, blood in his white Ford Bronco, a bloody glove at his estate matched one found near the victims. Prosecutors told the jury the odds of the DNA belonging to someone else were in the millions. This was supposed to be a slam dunk, but the defense didn't play the prosecution's game. They changed the whole conversation. Johnny Cochran, Robert Shapiro, F. Lee Bailey, the so-called Dream Team, didn't just poke holes in the evidence. They attacked the credibility of the entire Los Angeles Police Department. They claimed key detective Mark Fuhrman had a history of racist behavior and could have planted evidence. They hammered the mishandling of DNA samples, suggesting contamination was just as likely as guilt. Then came the glove moment. So, one of the most famous demonstrations in legal history. In front of the jury, O.J. struggled to pull on the bloody leather glove, which appeared too small for his hands. Cochran sealed it with the line that would echo for decades. If it doesn't fit, you must acquit. That rhyme, simple and unforgettable, became the defense's closing argument in a sentence. Beyond the courtroom, the trial tapped into deep racial tensions in Los Angeles, still raw from the Rodney King beating and the LAPD's troubled history with black residents. For many, the trial wasn't just about O.J., it was a referendum on the justice system itself. When the jury returned a not guilty verdict, after less than 4 hours of deliberation, cheers erupted in some communities while others were outraged. The prosecution had the science, the defense had the story, and in this case, the story won. Casey Anthony. In 2008, the disappearance of 2-year-old Kaylee Anthony gripped the nation and turned her mother, Casey Anthony, into one of the most hated people in America. When Kaylee's remains were found in a wooded area near the family's Florida home, prosecutors claimed the case was clear. Casey had killed her daughter, lied about it for months, and partied while pretending nothing was wrong. The state's case seemed overwhelming. They pointed to the smell of human decomposition allegedly detected in Casey's car trunk. They showed internet searches for chloroform on the family computer. They argued that Casey wanted freedom from the responsibilities of motherhood, and Kaylee's death was the way out. But the defense flipped the script. Led by attorney Jose Baez, they argued there was no direct evidence tying Casey to her daughter's death, no eyewitness, no cause of death, no conclusive forensic proof. Baez claimed Kaylee had accidentally drowned in the family pool and that Casey's bizarre behavior afterwards stemmed from years of trauma and abuse. They also attacked the prosecution's science. Experts disputed the reliability of smell evidence, and defense witnesses challenged the accuracy of the computer search data. The state's narrative, they argued, was built on assumptions and character assassination, not facts. The jury took just 11 hours to acquit Casey of murder, manslaughter, and child abuse, convicting her only of lying to police. The verdict sparked outrage. Many saw it as a failure of justice, but from a legal standpoint, the defense had done exactly what it needed to do: plant reasonable doubt and remind the jury that suspicion isn't proof. In the end, the Casey Anthony case became a textbook example of how a defense can dismantle a prosecution story, not by proving innocence, but by making the state's version of events seem uncertain enough to walk free. George Zimmerman. In February 2012, 17-year-old Trayvon Martin was shot and killed in Sanford, Florida. The man who pulled the trigger, Neighborhood Watch volunteer George Zimmerman, claimed self-defense. The case ignited a national debate over race, gun laws, and what it means to stand your ground. Zimmerman wasn't arrested immediately, which only fueled public outrage. When charges eventually came, prosecutors said Zimmerman profiled and pursued Martin, instigating the confrontation that ended in the teen's death. The state's witnesses painted a picture of an armed aggressor who ignored police advice to stay in his car. But the defense didn't focus on winning hearts. They focused on the letter of the law. Florida's self-defense statutes don't require a person to retreat if they believe they face imminent death or great bodily harm. Zimmerman's attorneys argued that once the fight began, he was overpowered and feared for his life. The defense brought in forensic experts to back up Zimmerman's account, highlighting injuries to his head and face as evidence of a violent struggle. They also capitalized on gaps in the state's evidence. No one saw the fight from start to finish. Eyewitness accounts were inconsistent. There was no conclusive proof that Zimmerman threw the first punch. And under Florida law, if there's reasonable doubt about who was the aggressor, the jury must acquit. The defense kept the case narrowly focused on that doubt, not the broader social issues swirling outside the courtroom. After 16 hours of deliberation, the jury found Zimmerman not guilty of second-degree murder and manslaughter. The verdict split the country. For supporters, it was the law working as written. And for critics, it was proof of systemic bias and the deadly consequences of loose gun laws. But in court, the defense didn't have to win the public argument. They only had to convince 6 jurors there wasn't enough to convict. Michael Jackson. In 2005, the King of Pop faced the most serious allegations of his career: child molestation charges involving a 13-year-old boy. For years, rumors had swirled about Michael Jackson's relationships with young fans. But this time, the accusations came with criminal charges and the full force of the Santa Barbara County District Attorney's Office. Prosecutors painted Jackson as a predator who used his fame, wealth, and Neverland Ranch to groom and abuse children. They brought in witnesses to describe inappropriate behavior, past allegations, and what they called a pattern of misconduct. In the public eye, Jackson was already deeply controversial, and the media frenzy surrounding the trial was relentless. But Jackson's defense, led by Thomas Mesereau, set out to dismantle the credibility of the accusers. They highlighted inconsistencies in the family's statements, previous lawsuits, and a history of seeking money from celebrities. Mesereau portrayed the mother of the alleged victim as manipulative and untrustworthy, someone who had a financial motive to lie. The defense also attacked the timeline of events, calling witnesses who directly contradicted the prosecution's version of what happened, and they leaned heavily on the fact that forensic evidence was virtually non-existent, no physical proof that abuse had occurred. Mesereau's courtroom style was calm but relentless. He kept the focus on reasonable doubt, not on proving Jackson's innocence outright. The prosecution's case, he argued, was built on shaky witnesses and sensational headlines, not hard facts. After 4 months of testimony and deliberation, the jury found Michael Jackson not guilty on all charges. The verdict was a career reprieve, though Jackson's public image never fully recovered. In legal terms, it was another reminder that in criminal court, the state's burden is absolute. And if the defense can make jurors question even part of the story, that can be enough to win. So, hey, guys, 4 cases. Four defendants who seemed destined for conviction. In each, the defense faced a tidal wave of public opinion, damning headlines and evidence that, at first glance, looked impossible to overcome. Yet they found ways to shift the focus, attack the state's weaknesses, and turn the trial into a contest of doubt instead of certainty. Thanks for joining us today at Due Process Daily. Throw us a like and consider subscribing to the channel to help us grow.